Welcome to February's session of Sharp Minds. I'm joined today by all the employment team. We all wanted to get in on the action on this session, which is an employment law roundup for 2023. I'm Julie Ban. If you've not met me before, I'm the partner in the employment team. I'm joined by David Leach, who's our associate, Kit Grierson, who's our junior associate, Tia, who's our trainee, and Medina, our paralegal. And today we're going to try and cover in an hour and a half quite a lot of information. If you could just ping me on a slide, please. Thank you. So as you can see, we've got we tried, usually in this session, we'll look at case law that has come up over the last year. But as you can see, there's a whole host of new regulations, consultation on new processes that come out that David's going to look at later. We're going to start with discrimination case law that Tia and I are going to cover, and then unfair dismissal and whistleblowing, some case law on that Kit will cover. And then David will come in on all the new regulations and the consultation that's going ahead. And Medina will end the session horizon scanning. We are recording the session. If you've got any questions, could you put them in the chat box? And I think the best thing to do is for us to come back to them at the end of the session, if that's all right. Unless we've got anything to deal with right now, we will press ahead, please. Shown with the next slide. Okay, so the first section, Tia is going to cover 3 disability discrimination cases that came out in 2023. Thank you, Tia. You're on mute at the moment, so you may need to unmute yourself.
Hi, morning. I hope you can all hear me okay. So the first case I'm going to cover, just onto the next slide, is ACOM Limited against Mr. C. Malone. So on the next slide, there's just a brief background to the case. So the claimant, who has dyspraxia, had been dismissed from ACOM in 2017. He brought a disability discrimination claim then, which ACOM settled. And then later in 2018, he indicated he wanted to apply for another role. So applications for this role were a basic online form and a personal profile. He emailed the HR department his CV and requested to make an oral application because of his disability and providing them details on this. But the company emailed him a number of times and told him he had to complete the form, but he should let them know if he was struggling with any particular aspect of it, to which he didn't respond to any of the emails. He repeated his wish to make an oral application, but this was denied, and the HR manager didn't call him at any point. So he then complained to an employment tribunal that ACOM had failed to comply with its duty to make reasonable adjustments in relation to his job application. So the outcome of this on the next slide is that it was held that the requirement to complete an online application form as part of the recruitment process put a job applicant with dyspraxia at a substantial disadvantage, thereby triggering the duty to make reasonable adjustments. Here, despite the applicant's failure to respond to the employer's email requests for details about his disability, it was held that the employer ought to have known that his dyspraxia meant that he would have difficulties accessing the online form. So the ET found a reasonable employer here would have telephoned that individual to ask for more details about his difficulties. So there are a few key takeaways from this case on the next slide. So in our view, this is not necessarily the best decision, but the case does highlight the difficulties you face as an employer with a vexatious litigant. So it probably would have been a complete waste of everyone's time to speak to him to enable him to complete the form, just because they weren't going to give him the role. And on top of this, he likely would have brought a claim anyway. But a few of the key takeaways include that the duty to make reasonable adjustments is triggered as soon as there is a whiff of additional needs. Therefore, you should always be open to be flexible with a process if someone says they have any specific needs for an adjustment. It's also your responsibility to make inquiries, not the individual's responsibility to say what they need. You should also consider advertising that there are alternative ways to apply if an applicant requires. For example, here, a specific form was required, and there could have potentially been a section that said, if you have additional adjustments, contact X, and then give the email and telephone number of someone trained in this, and they could potentially have considered alternative methods. And then another disability discrimination case I'll be covering today is Pilkington UK Limited against Mr. A. Jones. So some brief background on the next slide is that the claimant here was a long-serving employee and he was signed off work on grounds of mental health, having suffered from a debilitating shoulder condition. Whilst he was on sick leave, his employer received information that he'd been spotted wearing work boots, so then they engaged in private surveillance to monitor him whilst he was on leave, which showed him working on a local farm, engaging in physical activity. The employer then dismissed the employee on grounds of gross misconduct, namely a belief that he was undertaking secondary paid employment. But the employee later explained that he'd been visiting the community farm as part of therapy for his mental health condition, as facilitated by his GP. So the employee then lodged claims, including a claim under Section 15 of the Equality Act of unfavourable treatment because of something arising in consequence of disability. So the outcome of this on the next slide is that it was held that an employer's erroneous belief that a disabled employee was engaged in physical activity while off sick from work amounted to something arising in consequence of his disability. The the tribunal confirmed that an employer's belief that an employee is doing something, whether or not the belief is correct, can amount to something arising for the purpose of a claim under Section 15 of the Equality Act. So again, some key takeaways from this case on the next slide is that it acts as a warning to employers. So based on these facts, there were three potential something arisings in consequence of disability. So one was the use of private surveillance, two was the erroneous belief that he'd engaged in physical work, and three was the sickness absence. So employers should really tread carefully when dismissing employees on long-term sick leave in circumstances where evidence relied on or the employee's limitations or prognosis are unclear and subject to interpretation. Employers should also be ultra cautious when someone is on long-term sick leave because here they immediately conducted their investigation and didn't necessarily give the employee a chance to explain himself. So it's really important to just maintain communication throughout an employee's long-term sick leave and address any concerns early on before commencing any form of investigation and dismissal because it's key to avoiding these types of claims. And then onto the last disability discrimination case. So this is Mrs. J. Healy against Lancashire County Council. So some brief background. The claimant was employed at the council as an early years specialist from 2012, but then in November 2014 was diagnosed with cancer and then had a series of sickness absences. The council undertook a restructure and the claimant was ring-fenced for the early years quality improvement lead, which was almost identical to her role at the
Tira,
time.
oh, sorry, Tira, couldn't hear you then for a minute.
I'm so sorry. What's the last thing you heard me say?
So the council undertook a restructure and
Yeah,
she was being fenced, sorry.
she was ring fenced for two roles. So one was the early years quality improvement lead, which was almost identical to her role, and the second one was the senior early years consultant, and she expressed interest in the one that was identical to her role. She was in hospital at the time and asked what would happen if she was unfit to attend interview, and she was told it might be moved. She also asked if she could provide a written presentation, to which the council answered no. So at the time, the chemotherapy treatment she was having had impacted her memory and she'd been absent from work for some time. So a lot of the questions about the current challenges in the sector and what she'd done to address them significantly disadvantaged her during her interview, and then she scored poorly. On the next slide, she was offered the senior earliest consultant role, which was a demotion from her previous role. So a series of grievances and appeals were raised by her regarding the demotion, which were not upheld. Since she wouldn't accept the new role, she was issued a notice of dismissal, and she appealed this, alleging disability discrimination, which wasn't upheld. So she then went to the employment tribunal. The outcome of her claim at the ET is on the next slide, or the next two slides, sorry. And they actually ruled in favour on several of her claims. So for unfavourable treatment arising from her disability, namely cancer, this was because the council had made her interview for a position she'd effectively held for years, which was deemed unnecessary. Also, on indirect disability discrimination, as she was put at a substantial disadvantage when interviewed compared to her counterparts, this succeeded. It was also explained that the council had failed to take steps to remove such disadvantage through reasonable adjustments. The tribunal awarded her over £800,000, made up of basic award, personal injury, injury to feelings, aggravated damages, actual and expected losses, and pension loss together with interest. So there are actually quite a few key takeaways on the next slide from this case. So on processes, rigid policies which do not take account of protected groups or certain circumstances will almost always give rise to successful claims. So processes can be structured, but it's important that they remain flexible, just because blanket policies or managing restructures, for example, are almost always going to be inequitable. There's also a misconception that if you have a policy, it must be applied consistently to everyone. But this can actually end up having the opposite effect, because some policies may place some groups at a particular disadvantage. It also serves as a timely reminder that trying to use a restructure to exit staff who, for other reasons, you don't want to retain is always a risk, because it's usually quite obvious. It's also a reminder to ensure redundancy processes are transparent and that all the processes are necessary. So it's important to define circumstances where someone will be slotted into a role and where someone will need to reapply for a role. Another takeaway is not to ask basic questions about adjustments needed. You should actually think for yourself what difficulties an employee may face. So, for example, in this case, she was quite out of practice, so it could have been good to suggest any interview skills training or coaching she may have needed. Um, Local authorities will almost always face this hurdle, just because the tribunal will expect you to have a perfect process. So it's just important to note. Also, significant compensation was awarded here, which is important to look at, just because it must have been related to how they treated her. So it's just a reminder not to use restructures as a means of avoiding difficult decisions. And that's everything on the disability discrimination case. And then on to Julie, just for some training that we can offer on the next slide.
Thank you, Tia. That was great. I think I'd just add on those points. I think they're all really helpful reminders in terms of disability discrimination, in terms of reasonable adjustments, that the onus really is on you to communicate, to consult, and to find out what is needed, not on the individual. I mean, the evidence there that and it happens without completely unintentionally, that you have members of staff who are either on long-term sick leave or intermittent but long-term absences due to disabilities. It does sometimes build up a level of resentment within the team that they work in, and that can unintentionally sometimes come out through the next processes that are adopted, and it's just a really helpful reminder just to go back to basics in how you treat people. So we've added here that we do disability discrimination is one of the areas that we are seeing more and more and more in employment tribunals, and they're the hardest cases to defend because tribunals actively look for evidence that you haven't done everything you possibly could to support that individual. And we do offer training on this area. Disability discrimination, reasonable adjustments. We'll look at managing long-term sick leave. We'll look at assessing adjustments, redeployment and ill health retirement. And if you've got any questions on that, please do get in touch. Thank you very much. Tia, do you want to press it? Press ahead. Oh, I've just got a question, so it might make sense for me to deal with it whilst it comes up there. Forgive me. What are some of the things to bear in mind when considering ill health retirement, alternative communication with an employee on long-term sick leave? I think the key issue in terms of communication with someone on long-term sick leave is to try and agree with them what communication they want, how they want to be communicated with, and how often. Because you often find someone goes off on sick leave. If you try and contact them, they find it harassment. If you don't contact them, they say you've failed to contact them and you failed to support them. So you're often in a hole where you can't actually, you can't do right for wrong. And so in terms of communication, the best thing to do is to have a paper trail to show what you've actively tried to do to maintain communication, and you've consulted with them about that. In terms of ill health retirement, it's very much in terms of local authorities, it's a really strict process because it comes down to the pension regulations, and you have to obtain your occupational health certificate to say that the person is eligible for ill health retirement. And it's not easy to actually get that, but I would go through that. If you're not part of a local authority, you're looking at ill health retirement, you'd look at whether there are any benefits within your current pension scheme that would make sense. Otherwise, ill health retirement effectively means when you don't have the benefit of the local authority pension or something similar, it means dismissal due to incapacity due to ill health. And for that, it is about showing that you've followed a fair process and it's reasonable in all the circumstances to dismiss for that reason. I'm going to press ahead now. Thank you for your question. Thanks, Tia. If you could move on to this one.
Thank you. So this is a case on caste discrimination. So on the next slide, just some brief background to this case. So the claimant was a Hindi Tamil engineer belonging to the Shudra caste, who are recognized by the Indian government as a socially disadvantaged group that is at the bottom half of the social hierarchy ladder. So the claimant brought his claim against Betshall Limited in November 2020, accusing his former employer of passing him up for promotions, giving him bad performance reviews, cutting his bonuses, etc., allegedly on the basis of his Shudra caste. So there's some relevant legislative background on caste discrimination law. So in 2013, legislation passed requiring the UK government to make caste an aspect of the protected characteristic of race. But despite various calls to do so, it ultimately opted not to. But later in 2015, there was an ET decision in Turkey against Chandok, where the ET found that caste could satisfy the legal definition of ethnic origin. However, in this case, moving on to the outcome, the tribunal ruled that the claimant couldn't pursue race discrimination claims against his former employee because of his caste here, as it doesn't fall within the meaning of ethnic origin under UK law. So the judge here said that even though his Tamil ethnicity might be covered, it cannot be said that there is a long shared history as far as his caste is concerned, nor does it have cultural traditions of its own, including family and social customs and manners. The tribunal also accepted that none of the alleged discriminators were aware of the claimant's caste, and this didn't play a role in their decision making, as a lot of the grievances were as a result of mediocre performance. So here the judge actually went against the previous 2015 decision that I spoke about and concluded that whilst accepting that the court in Chandok found that caste could come within the meaning of ethnic origin, this tribunal didn't find sufficient evidence to conclude that, and then they dismissed the claim. So a few key takeaways from this is that the case highlights that at present caste doesn't fall within the meaning of ethnic origin under UK law and therefore is not a protected characteristic for the purposes of the Equality Act. However, employers should remain mindful as caste discrimination is on the tribunal's radar and could be considered to fall within the meaning of ethnic origin for the purpose of discrimination claims in the future. So the more cases like this come up before the tribunal, the more the tribunal and government will review the law on this. And it's likely that if it keeps coming up, we will get a decision at some point that caste does come within the meaning of ethnic origin. And this could actually see the Equality Act being amended in the future to include caste. And that's all from me on caste discrimination. So I'll pass back to Julie.
Thank you, very much, Tia. That was really interesting. So I'm going to cover this really meaty subject, the battle, and I call it a battleground because it's a really toxic debate, mostly at the moment surrounding the freedom of expression to express gender critical beliefs, and that when that conflicts with trans rights. And it's playing out in the workplace and it's playing out in the employment tribunals. And there's an awful lot on both sides of the spectrum, people trying to win political arguments, and they're running those debates through the employment tribunals, and employers are getting completely caught in the middle. So I've put a little bit of background information here just to give an idea of what we're talking about. The Equality Act 2010 found that gender reassignment was a protected characteristic, and that there's been subsequent cases that have found that under gender reassignment that covers people that are on a spectrum, on the spectrum of gender reassignment. Doesn't necessarily mean people that have decided to go through, have already gone through, or considering some way, or going through any sort of physical gender reassignment process. So it covers non-binary individuals as well. And in 2021, despite obviously 11 years of that protection, a couple of polls there showed that trans workers still felt that they faced conflict in the workplace, and 65% were hiding their status at work, which was an increase from 2016. So in all respects, it seemed like from that side of this debate, things were going in the wrong direction, and it may be as a result of that type of feeling that the trans community got more active, and in 2021, you may be aware, Kathleen Stock was hounded out of a role at Sussex University because of her gender critical beliefs, where she effectively argued that you couldn't change your sex. And then you will all be aware of, and I'm not covering in any detail, the Mayor for a Starter case in 2021, where the Employment Appeal Tribunal found that should say gender critical beliefs were protected philosophical beliefs. So that's the first time in 2021 that we got that decision that those beliefs were protected. And it was in 2022 that the remainder of her claim was considered at the Employment Tribunal, and the tribunal found that she was subject to discrimination because of those beliefs. And subsequently, there have been a number of decisions, and I'll go through them, that took place last year that have looked at that area. So we're looking here at, so the law, first of all, section 7 is a person will have protected characteristic of gender reassignment, as I say, if they're proposing to undergo or undergoing or have undergone a partial or completed process. And as I say, that also covers people on the spectrum, including people that consider themselves non-binary. Section 10 of the Equality Act, religion means any religion or lack of, and belief means any religious or philosophical belief. Article 9 of the European Convention of Human Rights, which is one of the key issues that has been discussed in these cases, the freedom of thought, conscience and religion. So everyone has the right to freedom of thought, and it's only subject to such limitations as are prescribed by law or necessary in a democratic society, or for the protection of the rights and freedoms of others. So it's not an absolute right. It has to be balanced with the impact on others of what you're choosing to think about. And equally, in terms of Article 10, you've got the right to hold the opinions and to express them, but that is also subject to only subject to such restrictions that are necessary in a democratic society for the protection, reputation or rights of others. If you could ping me on a slide, please. So we call this a toxic debate, and it's been going through the tribunals. Miller was another one in 2020, and this was in the civil courts, and they noted that there was a rigorous ongoing debate about trans rights, and they're showing that sometimes those involved in the debate are readily willing to label those with different viewpoints as transphobic or as displaying hatred when they are not. It's clear there are those on one side of the debate who simply will not tolerate different views. I think that's obviously written in the form of considering the evidence that Kathleen Stock gave in that case, but I would suggest that actually there are people on both sides of this debate that are not willing or able to tolerate different views or to look at ways of resolving these conflicts. And if we move on a slide, so the tribunal are looking at this and they're answering these 3 questions. Is the belief protected? So when you're looking at philosophical beliefs, is the belief protected? So at the moment, you've got Granger that set out the test for what amounts to a philosophical belief, which I won't go through again in any detail here. It's a long-standing case. The For Starter case said a belief that you cannot change your sex is protected belief. Is there a close nexus between the belief and the manifestation of the belief? So is there a close enough connection between what the person says that they believe and how they have communicated and the communication that they have put out? And are the respondent's actions against the person manifesting that belief proportionate? So if you can move on a slide, please. It's really this last question that has caused employers the most difficulty. I mean, this is an area that, like race discrimination or sex discrimination, which we've known about for 20 odd years, which we all readily understand that it makes sense to you that it's protecting the rights of one person, and therefore when you have a complaint about harassment, you look into it very seriously and you take action. So you would think in those sort of situations, if someone has a complaint in the workplace from the trans community, that you would do the same, but you've got this difficulty where you've got these conflicting rights. So the tribunals say you've got to look at proportionality, and that was a Bank of Mellot and HMRC case. So you identify the employer's objective or reason and ask, was the objective of the employer's conduct sufficiently important to justify the limitation of the protected right? So why did you do what you did, and what was your objective? If so, was the measure rationally connected to the objective? So is the outcome you chose sufficiently reasonable to justify meeting your objective? If so, could a less intrusive measure have been used without unacceptably compromising the achievement of the objective? And finally, balancing the objective against the severity of the impact. So those are the sort of things that the tribunal expect you to think about effectively, because that's what they will be thinking about if this gets to a tribunal. If you can ping me on a slide, please, Sean. So Higgs and Farmer's School, so this one covered, she actually went down a religious belief rather than a philosophical belief, but it has the same type of issues. So she worked in a school, she was a pastoral administrator, and someone contacted the school with a complaint that she was posting on her Facebook account links to articles which criticised gender fluidity as a perverted version, and also demonstrated other prejudiced views which could suggest she was transphobic and homophobic. So the school asked her to take them down, and she refused, and they dismissed her for gross misconduct on the basis of discrimination and damaging the school's reputation. And what they basically said was, we don't think that you are transphobic or homophobic, but your Facebook account and those articles which you refuse to take down would suggest you are, and therefore your link to us as a school and your role as a pastoral administrator for children that may have either things going on at home or their own feelings is damaging our reputation. So she alleged direct discrimination and harassment in the respect in respect of her religion, which I think she was Christian. The tribunal at first instance held that her various views on non-binary people were protected, but she wasn't dismissed because of her beliefs, but because her actions or the way that she was posting were reasonably perceived as homophobic and transphobic. So it wasn't that they believed, it wasn't because of what she believed, it was because what she was actually putting out there. And they also said the claim for harassment failed because the school wasn't related to her. The school's action wasn't related to her beliefs. It was related to her refusal to take down posts that looked like they were homophobic or transphobic. And this went to the EAT. If you could pin me on a slide, Sean, please. And the EAT basically said this has to be remitted back to a tribunal because the tribunal have got the decision wrong. They haven't looked at whether or not there's a close enough nexus between her beliefs and the manifestation of her beliefs to consider whether when they made their finding. But they gave this guidance, which I think is really useful points that you should consider if you are faced with this type of situation. So the content of the manifestation and the tone used, so the extent of the manifestation. So we're looking here, manifestation, such a strange word, isn't it? We're looking here at what the communication was. Was it verbal communication? And if so, where was that? Was it anywhere near work? Is it on social media? Is it on private social media? Is it in public? What is the connection to the workplace? Things like that. The workers' understanding of the likely audience. So who are they publishing or posting to? Who do they expect to see the information that they're passing on? The extent and nature of the intrusion on the rights of others, and any impact on the employer's ability to run the business. So you've got to look at really here on this one and the next one, is there a reputational risk? Is there a close enough connection between those posts of someone who happens to be your employer and you? Can you distance yourself from it and say that's her own views, or is it something about what you do or how what he or she does, that means that it is intrinsically linked and it would damage your reputation? Whether there's a potential power imbalance given the nature of the worker's position or role and those of whose rights are intruded upon. So also you've got to consider context. So in this case, she was a pastoral administrator, and therefore she was responsible for that sort of care and support and looking at these issues in an empathetic way within a school. The nature of the employer's business. I mean, this is key for you as public or voluntary organisations, because the members of the public do expect you to hold higher standards in terms of what you're doing. They also expect your employees to do so. Is there a potential impact on vulnerable service users or clients? And whether the limitation imposed is the least intrusive measure open to the employer. So those are the sort of things you need to think about. If you could ping me on a slide, please. So, as I said, that's the guidance that has been put forward. So we're going to go through some of the cases that have were heard last year. Get my words right. And this one's a difficult one because the Arts Council suspended a grant due to alleged transphobia of a recipient charity. And the Deputy Chief Executive of the Arts Council hosted a virtual drop-in session for all staff. And the claimant in this, at that drop-in session, challenged the allegation regarding the anti-trans and asked how gender-critical views were protected at the Arts Council and in the arts. And the Deputy Chief Executive then emailed all staff stating that it was important that the Arts Council treated all colleagues with respect and dignity, but indicated his personal solidarity with the Arts Council trans and non-binary colleagues. And that in some way could potentially have seemed to trigger a response by other employees. And an employee emailed all staff referring to a grievance raised by the LGBTQ plus working group about that drop-in session, and alleged that homophobic and anti-trans views of a senior member of staff had been on there. It included a link to a petition referring to Allies support sheet, and the comments added to the petition referred to gender critical beliefs as anti-trans, bigoted, a cancer, and transphobic. The claimant did complain, and the petition was reviewed and removed once it was noticed after it was up for only 26 hours. So the Arts Council did the right thing in taking it down. They did investigate the process, and disciplinary proceedings were taken against the employees involved. However, the claimant raised a grievance, which was upheld, and found that the tone and content of the email and the accompanying petition were capable of causing offence to people holding gender critical beliefs. So in many respects, the Arts Council did all the right things. The claimant still pursued a tribunal claim. If you can move me on a slide, please. And the tribunal found, oh, I must be missing a slide. Go back one, sorry. But basically, the tribunal found that the actions of the Deputy Chief Executive in posting that, and then which triggered the petition, did amount to harassment, and as such found in favour of the claimant. And this is basically a really handy warning for all employers to ensure that you think about what to do now to avoid the conflict in the workplace, to think about training, to think about respect and dignity in the workplace, and a variety of other things for all employees. Because although the Arts Council did all the right things once they're aware of the concerns, effectively, they didn't nip it in the bud early enough, and that's effectively what the tribunal found in this case. If we move on to the next slide, please. Mead and Social Work England and others. So this is a very recent case. It was heard at the back end of last year. The claimant in this case was a social worker, and she had a private Facebook page with about 40 people on it, and she reposted a number of articles and images on this private Facebook page on issues, a variety of issues, such as women in that should say sport, sorry, I haven't done my review of my slides, safe places for women, and a variety of other things. But there were a couple of satirical cartoons on there, and one about dead naming and things like that. And one of her Facebook friends was a trans person, and they alerted Social Work England to the posts and alleged that they were offensive, and sent about 70 posts to Social Work England to review. Social Work England, as is their process, when they get a complaint, then they determine whether there's anything in that complaint. So they opened a fitness to practice investigation, and they did a review, and they produced a report that said some of those posts could be considered discriminatory, and the claimant accepted at the time that she hadn't really thought about the posts. She didn't really think about the effect on others, and she could see why they may be offensive. She agreed to do additional training, and she was offered a number of options which Social Work England do. So you can accept their initial findings, which at this year was a warning on her record for 1 year, impaired fitness to practice for 1 year on her record, or she could proceed to a hearing and dispute that, initial assessment. And she accepted the warning. So her employer was then notified, the council where she worked as a social worker was then notified of the warning, and received the Social Work England report and suspended the claimant pending an investigation. And because of that, the claimant then asked Social Work England to reopen the matter as she wanted to contest the outcome, which isn't really part of their process. So that took quite a long time. As part of the investigation, the council reviewed the evidence and found that most of the posts were not discriminatory, but there were some that could be discriminatory. And it went to a final warning. She was suspended for quite a long period of time because she delayed the process because she didn't want the hearing until Social Work England had made their decision, and it took them nearly a year to get to that stage. So they gave her a final written warning. Social Work England then dropped their fitness to practice process and removed the warning from her her record. And when she appealed the final written warning on appeal, it was overturned because of Social Work England had determined that this was no longer an issue, and therefore that was one of the key reasons why she was given a final written warning, and therefore there was the appeal was effectively successful. So she brought a tribunal claim. If you could ping me on a slide, please. And the Employment Tribunal found that both the Council and Social Work England's actions amounted to harassment on grounds of gender critical beliefs. And I put there at the beginning one of the posts that that she had, one of the they said it was a satirical cartoon that she had posted on, that both Social Work England and the council found was concerning, and they both felt that it was conflating transgender with paedophilia, which was offensive. But the tribunal looked at all the posts, and they basically found that there was no post that she had sent that was outside the reasonable bounds of the legitimate manifestation of the claimant's beliefs. They went through it all and they said, we're very up to date with this debate on gender critical beliefs. We know what the debate is. It is a debate that is a public debate, and employers and the regulator should be open for individuals to get involved in that debate. They found that while the claimant accepted in cross-examination that the cartoon that she'd posted, she understood it to be concerns about trans women being in effect predatory males, the employment tribunal found that actually that it constituted a reasonable satire and addressed a legitimate safeguarding concern that some trans women retaining male bodies could exploit their position to have access to young and vulnerable girls. So quite we consider quite a shocking outcome, really, and it's taken the law quite a bit further in one direction that I think was probably expected by the EAT when it made its finding in For a Starter. If you could move me on a slide, please. The key takeaways in Mead, I think, are about the disciplinary process. So this disciplinary process was triggered by an external factor, well, two external factors. One, it was an external Facebook post on a private site, but then it was the regulator undertaking the investigation. But the key thing to remember is if you're ever in this type of situation, irrespective of the nature of the concerns, it's your disciplinary process. It has to be your investigation and your decision based on your thorough investigation that you have sufficient grounds to make a finding yourself. You can't rely on somebody else's decision unless obviously someone has been found guilty of a criminal act. I think you can rely on that, but you can't rely on allegations of that. You've got to be sure that if you're going down a misconduct process, that you can investigate and you can make your findings. Consider carefully conduct outside of the workplace that is not in the public domain. This was a private Facebook page. I'm not suggesting all posts on a private Facebook page wouldn't be subject to disciplinary action if there's a sufficient link between those posts and the workplace to show that it would impact on your reputation, but it's something to bear in mind. In this case, Mead was suspended, and that suspension was lengthy. And the initial decision to suspend was not harassment, but the difficulty the council had was that it maintained the suspension because it really was usual process that once someone's suspended, that they remain suspended effectively until you've made a decision, the disciplinary decision, if it goes that far. And I think a real learning point is that if you're reviewing your suspension, you look actively at each stage you review it and decide whether there's actually a need for that person to remain suspended. Don't rely on the previous decision that it was. You've got to actively make that decision. Check template letters. If you've got template letters for your warnings, please check them before they go out. So this final written warning was it was a final written warning for 2 years, when the fitness to practice warning from Social Work England was only for 1 year. It was the person who made the decision wasn't, she said, oh, that, the length of the warning, that's something that HR decided. That was nothing to do with me. And those sorts of things, when they come out at tribunal, look really tricky to explain. So be very careful what you put in there. And also final written warnings in this type of sphere, look at what you're saying, because usually you're saying if you do something again like this, you might be dismissed. So be very careful about what you're saying they can and cannot do going forward that might be subject to sanction. because in this case she said, I don't know, I don't feel I can say anything anymore because of this. So you've got to really be able to explain what you mean by that. And ensure steps to bring an employee back into work following suspension are considered very carefully. So what is said to them, what support is given to them, and what action is taken. Next step, please. Another case, Phoenix and the Open University, and I raised this also just to get across the magnitude of the public interest in this sphere. So Jo Phoenix was a professor of criminology, and the tribunal found she was constructively unfairly dismissed on the 2nd of December 2021. So in June of that year, she established a gender critical research network at the Open University that focused on the importance of sex bodies in different academic disciplines. Her colleagues considered that this network was transphobic, effectively, and they launched a public campaign, and they had 360 signatories on that from across the university and various other places condemning the research group. And they basically, one of her colleagues compared her to a racist uncle. She was instructed by a head of department not to discuss her research in her own department. So this went to an employment tribunal. It was a 23-day hearing. There were 20 witnesses. There was a 5,000-page bundle. 40 to 50 people watched this remotely. The hearing took place, and they had 2 rooms to undertake the hearing because that many people wanted to attend to watch it. It was subject to live tweeting, and during the hearing, a member of public sent an email to one of the witnesses that was really offensive, and this public reaction to this situation means that your witnesses are on public display, and in the Mead case and in this case, the live, and in for a starter, and Alison Bailey, the live tweeting that goes on means that every single witness, their name is then recorded and everything that they did, and then there's a public discussion about them and everything. It's very traumatic for a number of people. As I said, the tribunal held that she was subject to harassment, direct discrimination, constructive unfair dismissal, and victimisation. Basically, the university had failed to protect her from attacks for fear of being seen to support her gender critical views. I think it's probably more likely they failed to protect her from attacks for fear of being seen to be seen to be against the trans community, and you're put in that very difficult position of walking a fine line in that type of situation. If you can ping me on a slide, please. Finally, in this area, it's not on gender critical beliefs, but it's following this same sort of view of political beliefs, or people trying to push that they are philosophical beliefs and they're deserving of protection. Holbrook and Cornerstone Chambers. So I've said on others because there's a variety of cases ongoing. So Holbrook was a barrister at Cornerstone Chambers, and a participating counsel on the LBLA framework. Some of you may be aware of this matter. In January 2021, he was a regular tweeter. He did lots of different articles in his own time, but he responded to a tweet by the European Commission of Human Rights that publicised a settlement in a case involving a black schoolgirl who had been excluded from school for having an Afro hairstyle. And he wrote, these are his words, the Equality Act undermines school discipline by empowering this stroppy teenager of colour. The public backlash was significant. So many barristers tweeted vilifying him. The Cornerstone Chambers acted immediately, asked him to take it down. He refused. He tried to resign. They refused to allow him to resign, and they basically took a vote and they expelled him. he brought a claim against Cornerstone Chambers. He didn't do so immediately. Bear in mind, he's a barrister, so he is expected to have a level of legal knowledge. He believed, because he'd asked somebody that you had 6 months to bring a claim for discrimination. He didn't even do it in that period of time. But when the EAT decision of For Starter came out, he thought that that would give him more of a chance to succeed with his arguments, that his views in terms of being a critic of identity politics, and he classes it as social conservative beliefs. So his views were more likely to be protected. So we went to an employment tribunal and the claim was struck out as being out of time. And he pursued an appeal at the EAT, and the EAT also said it was out of time. It's not a unique case. For Starter wasn't a unique case. If you believe you've got philosophical views, you bring your claim within the 3 months and you run your argument. Subsequently, because during this process, a number of the participating local authorities on the LBLA framework wrote a joint letter of complaint to Cornerstone Chambers about his behaviour. He has subsequently written to them all doing data subject access requests and brought a claim against 9 to 10 local authorities stroke other similar organisations, claiming that they've subjected him to harassment, discrimination for refusing to instruct him, and they induced Cornerstone for in taking discriminatory action against him, and that is still ongoing. But I just wanted to put this in because just to show you the breadth of issues that are ongoing in this sort of debate. If you can ping me on a slide, please. So key issues, as I say, the debate continues to rage. There are increasing number of claims coming out through here. The For Starter case and subsequent cases have given a lot of confidence to individuals to think that they have a right to do or say whatever they think in this arena. And I don't know if I am a secret viewer of Mumsnet, and some of the comments on Mumsnet posts in respect of this debate are, I would say, quite horrific, but they believe that they are protected. They can say that. They believe that going to say similar things in the workplace, that sort of thing. So it is something that is really high on the agenda and something that you really need to be thinking about how you're going to approach. There's a real reputational issue here. So crowdfunding for claims means that these allegations are known well before a tribunal hearing actually takes place, where usually that's when any allegations are public. And to be perfectly honest, as you'll all know if you've been through tribunals before, tribunals hearings are not really that interesting to that many people. It may get picked up by a local government lawyer or something along those something along those lines in terms of posts about decisions, but they're not really that interesting on a public forum. However, these cases are getting on the front of your broadsheet newspapers. The crowdfunding means the allegations are out there and are being discussed, you know, maybe 12 months before your hearing. So Bailey raised £550,000, Mead raised £137,000. Tribunal tweets are turning up at these hearings and are tweeting out every single word that is said by everybody in the hearing, naming each person involved. What you should be aware of, each case is really fact sensitive. So at the moment, I would still say it's really difficult to assess how a tribunal will find on the facts. And as you can see from the decision in the Mead case, and obviously me raising it in that way, you can probably get a hint of where I think in terms of that particular post and why I still think it's of concern. But it's something that tribunals are looking at very carefully and are making, and we've not got enough case law yet to have a full grounding of where we think they will go on these sort of things, and so we're walking that a very fine balance between managing everybody's expectations, which I think is really difficult to do, certainly as an employer where you take equality and diversity seriously. Could you ping me on a next slide, please? So action. First of all, be prepared. Review your policies, consult with your interest groups if you do have them about what they think you should do in these situations and how they think you should manage conflict. Training's real key, so train your managers about understanding this arena, agreeing processes, and don't immediately consider disciplinary action if someone raises a grievance. That's what you'd ordinarily do if someone says, I feel harassed by that because of a protected characteristic. Your immediate reaction is to say, that is a disciplinary action. It's potentially gross misconduct. We're going to investigate you for that. Because actually, you may find, if you look into it, that you have to determine that actually, just because someone finds it offensive doesn't necessarily mean that it is a harassment. It may be a legitimate expression of their protected beliefs. Consider carefully whether comments and social media outside of the work does actually impact on the work or that person's ability to undertake their job. I think in terms of that area, it maybe you need to look again at your social media policy. More and more people are active on social media. You may want them to be very clear on their own social media, have something that says these are my own words and nothing to do with anybody else, that sort of thing. But do look at that. You can ping me on a slide now, please, Sean. And finally, as I say, we have also put together some management training on this area to look at getting yourself in a position where you feel confident and comfortable in dealing with this if it does arise in your workplace. Please do contact us if you want to hear a bit more about that. And that's me. I'm sorry, I've taken up a huge amount of time and I'm now going to ping on to Kit. Thank you.
Thanks, Julie. So in contrast to Julie's area, which is quite a rapidly changing area of law, unfair dismissal is relatively fixed. So I'm just going to talk about a few cases which ultimately are sort of clarifying the understood position on law, and then one recent development on whistleblowing. So the first case is Omar and Epping Forest, and this relates to making a resignation in the heat of a moment. So the claimant had resigned a number of times and withdrawn it. And then on one occasion, he had an altercation with his manager and again resigned in the heat of the moment. However, when the employer invited him to retract, not to put it in writing, he then spoke to the CEO to try and retract his resignation. Subsequently, the CEO spoke to the manager and they said, yeah, we don't want him back. We're going to treat this resignation as final and he needs to work his notice. Obviously, he was unhappy about this and brought an unfair dismissal claim, saying that ordinarily the employer can treat that resignation by its plain and natural meaning, but there are also special circumstances in this case which dislodges the normal rule. The ET disagreed and found that the words used by the claimant were unequivocal and he clearly meant to resign. This was then appealed to the EAT, who disagreed with the employment tribunal and have set out the correct legal principles that you need to consider when someone resigns in the heat of the moment. Can I have the next slide, please? So the first point is there has to be an objective understanding. It's almost irrelevant what the claimant themselves think. It's more important what a reasonable employer can understand by the words of the individual who's resigning. Moving on from that, you cannot normally retract a resignation. It has to be through agreement with the employer. However, the exception to that rule, which relates to this case really, is in exceptional circumstances, the employer may have to consider a cooling off period before acting on the resignation. These are circumstances where the employer really needs to satisfy themselves that the words or actions of that individual really can be constituted as a resignation. And finally, the actual resignation. If an employee changes their mind after resigning, then this would not normally be sufficient. And so the employer needs to consider, was the resignation seriously meant really intended and conscious and rational. Can I have next slide, please? Okay, another area of law which again is relatively fixed, and I'd say this is more of a clarification, is to do with redundancy situations. In Joseph de Banks Haycock and ADP, we had an individual who worked for a recruitment company. He was part of a redundancy process, which ultimately led to him being given notice of his redundancy, which he unsuccessfully appealed. He brought a case to the employment tribunal arguing unfair dismissal, primarily because the consultation process was ineffective because it hadn't been done at a formative point in the process. ET disagreed, but then he appealed that decision to the EAT, and the EAT allowed the appeal, finding that the case law on reasonableness in redundancy procedures requires workforce consultation at a time when employees have the potential to affect the decision. Can I have the next slide, please? So, next slide, please. Yeah, so I'm not going to read everything on the board, but the key point here is actually many of the people. Can you go back one slide? Yeah, so the main point here is quite often with a redundancy process with a large employer, you'll be able to go through the steps quite carefully. The timings will be met. You will have the consultation meetings. However, what I'd underline from this case is it's not just enough to go through a box ticking exercise. Where you also really do need to substantively grapple with some of the feedback you're receiving from claimants. It's not enough to make a decision and then effectively push through the decision through the procedure. The procedure really is there for a reason. You know, the consultation needs to be received at a formative stage to inform the decision. So I think that's what I'd take from that. But then it also highlights some of the other standard rules which you should come back to when conducting a redundancy process. Next slide, please. Final case from me is pivot over to whistleblowing. It's a Scottish case, but is relevant as it went to the EAT. So in this case, the claimant was a teacher who made protected disclosures about the practices at the nursery she worked at. As a result of this, the nursery referred her to the General Teaching Council of Scotland regarding her fitness to teach. She brought an employment tribunal case for whistleblowing and sought to argue that because she had blown the whistle, she had been subject to the detriment of the retaliatory referral. The ET agreed with her and she was successful, finding that she had effectively done a protected disclosure, and also the only reason, well, potentially not the only reason, but the primary reason she had been referred to the GTCS was because she had made these protected disclosures and it was done in retaliation as a detriment. However, when it came to compensation, the ET found that she could not claim compensation for future loss after the point that the GTCS decided to investigate further. They found that that broke the chain in causation because potentially the referral may have been made in bad faith, but because GTCS was investigating, there was potentially a case to answer here. Can I have next slide, please? Next slide, sorry. So at the EAT, the ETs disagreed with the lower tribunal on the reasoning for compensation. They found that for something to be an intervening act which breaks the chain of causation, it must become the sole effective cause of the loss, damage, and injury suffered. And actually, the referral and the decision by GTCS to investigate did not do so in this case. So that's it for my update, and I'm just going to pass on to the next speaker now. Thank you.
Thanks, Kit. So yes, I'm going to start looking at updates to regulations that are coming in mostly from the 6th of April. But the first one really to look at has been the changes to holiday pay. So next slide, please. So the main changes really here are creation, for lack of a better phrase, of new worker status in relation to holiday pay only. So this has been the creation of a part-year worker or an irregular hours worker. And these regulations will be coming in for leave years that start on the 1st of April this year. So just a quick reminder for those, a leave year basically begins either by, it states in the contract, you have a collective agreement, workforce agreement, which can be as simple as an email saying, the leave year starts on the 1st of January, for example. Or if you have none of these, then it's the anniversary of their start date. So for anyone that's had a leave year that's already started in this calendar year, obviously you won't be affected until 2025. So for example, where this is a lot going to be seen for local authorities and other people is going to be schools, because mostly their leave years start in September. And that's where things are going to come in. So for this, it's a limited maximum of 28 days annual leave for these sorts of workers, and effectively kind of creates a new way to pay them leave. So it's either the Harper holiday way. So if someone's taking leave, you calculate their hourly rate or their weekly pay by calculating back 52 weeks or up to 104 weeks to get 52 weeks of an average pay if they have that time served, and then obviously pay them out at that weekly rate going forward. Or you can choose to pay them at the 12.07% that was got rid of by Harper Holiday and has now been brought back in for that pay, the hours for that specific pay period. So the pay period is either going to be a month or a week, however you pay someone, and it must be paid at that time. That is the main classification there. So part-year workers are, as it says there, that they are only required to work part of the year, and effectively there is at least 1 week where they are not required to work and they are not paid. So that might be, for example, teaching assistants or administrative assistants in a school. They are not required to work for parts of the year, namely the summer break, and they're sometimes not paid for that. So if they are not paid and they are not working for that week, you can make them part-year workers. And irregular hour workers are for people who are wholly or mostly variable on the hours that they work in each pay period. Now, with this one, you must also look at all contracts that you have with them. So, for an example, would be you might have a library worker who has variable hours, but they also might have another contract with you where they have almost guaranteed hours of 37 hours per week. Now, taking that all in the whole, they're unlikely to be variable hours. So it's just something for people to be looking out for if you are going to be pushing people who meet these definitions into the 12.07% rolled up holiday pay way of paying someone. It's something to be urgently looking at, as obviously it's going to start in the next couple of weeks, and really consultation with unions and the relevant employees or workers that you're going to do this to needs to be done pretty quickly, as it is a substantial shift in how someone might receive their holiday pay going forward. Next slide, please. But next, so yes, there's some more regulations for us to look at. And the biggest one, I think, for most people on their radar is flexible working. It will become a day one right as of the 6th of April. So at the moment, anyone you've basically started employing, it's a countdown to the 6th of April for a day one right. The new thing is they'll be allowed to make 2 requests a year, but they can't make 2 concurrent requests. So obviously they have to completed everything first of that request, including any appeals they might have, and then obviously they can make a second request. You must complete all aspects of a flexible working request within 2 months. This has been a reduction from 3. And also, if you are going to reject or are minded to reject a flexible working request, you really must sit down with the employee and their representatives and discuss this. You must try and find alternative ways. You must see what you can do first to try and meet their request before you reject it. And again, the rejections must be based on one of or more than one of the 8 business reasons which have not changed. I think the big important thing really here is do not delay these requests. There are still claims going on about breach of statutory processes. So recently the FCA won half their case and lost the other half on a flexible working request that had been made by an employee. They won on the fact that they had denied her flexible working request, and they were actually complimented on having done a very thorough process. However, they fell over on the fact that they needed to extend the deadline, and they didn't extend all the deadlines in writing. They extended one. I think this was in relation to an outcome or having a meeting, but they had actually not extended the deadline to conclude the process. And so they lost the statutory request and had to pay out the employee, I think, about 680 quid, but something, obviously, it's money going in the wrong direction. So the right to request predictable working patterns, this is something that's coming in September this year and is for agency workers, anyone that has the inherent lack of predictability in their working patterns. So as it says, their number of days a week, times of the day, and the period for which they are contracted to work for you is just not really set. Now, one thing here is that they are likely to need a 26 weeks of continuous service before you can really make these requests, something obviously is different to flexible working. And here you'll have 1 month to fully respond to this request. Now, ACAS is in the process of producing a new code for guidance for employers. There's just something, obviously, again, to be aware of in 2024, that if you have a lot of workers on very variable patterns, it's more requests that you're going to have to deal with and deal with them quite speedily compared to flexible working requests for employees. Next slide, please. So fire and rehire. Now, most local government, most employers generally do have quite a good policy on fire and rehire as a last resort. Now, this whole new code of practice has come out of the fallout from the P&O and mitigated PR disaster that they did about 18 months to 2 years ago, where they pretty much sacked all of their employees who were on their ships and then hired new people on less favourable terms. Now, whilst not technically a fire and rehire because they hired new people, not the same people on different terms, it still triggered a lot of public backlash, and new government guidance has been published on this. So effectively, fire and rehire is still a legitimate thing. It's just must be the last resort, and it's going to be very, very rare for you to use. The code will not apply if it's just a genuine redundancy situation. However, if you are going to have genuine redundancy with change of terms, you're likely to have to follow this code of conduct. And effectively, you must not use dismissal as a negotiating tactic. That is probably the key takeaway from that. If you still have unions, or you do have unions, as to say, obviously you must remember to consult them as part of this, and also be very, very aware of your inability to go forward on putting offers towards members that have not really gone through the full union presentation, because otherwise you will end up having claims from the unions of putting unfair offers towards people. And this new code will carry a 25% uplift. So whilst you are not bound to follow the code, if you have a case about fire and rehire and you don't follow the code, the tribunal will be open to have a look at it, and obviously could award a 25% uplift in compensation if they found you have not provided a suitable reason for not following said code. Next slide, please. So carers leave, new set of leave coming in. It's an unpaid day one right. And this is to supplement dependence care, emergency care leave, all the other leaves that people have in relation to family-friendly rights. The interesting one about this one is obviously you can take it in full days, a full week, half days, or a combination thereof. So it's a week's worth of leave. And it's really there for people who have someone who is independent, for them who has a care leave, but it's not an emergency situation. So an example that has been given is, I might need to take one of my parents to look around a new care home because of the care need that they have got. It's not an emergency because I know about it, so I can't rely on other emergency leave, for example. Now, the test really is for dependent care leave. Is kind of starting point is anyone who's got a long-term care need or has a physical or mental impairment, i.e. disability under the Equality Act. The only real distinction is it can't be a tenant who's living with you. They don't meet this dependent classification, but it's anyone in your family or anyone that does have a dependent care need of you. You must give annual leave. Must give notice, and a bit like annual leave, it's kind of double the amount of leave you're taking going forward. That's minimum. Obviously you can ask for more, but it's just kind of something to look at when people are asking for this leave. The employer can ask to postpone the leave. However, I would issue massive health warnings on going down this process. You must have an exceptionally good business reason for doing so. Mainly, obviously, things will fall over if this person takes this small amount of leave. And I think the answer would be, if they'd asked for annual leave, would you have given it? If the answer is yes, then you should have been giving this leave as well. And any delay must be as short as possible before saying, we need to delay this. And that's mainly because this will be giving a new protected status, in the sense of, you're asking for this leave, you're taking it, and you suffer a detriment. You can bring, or employees can bring, a claim in the tribunal for this. So it's why I say, really be very careful when you're trying to delay this, because someone will probably argue that the detriment. So check your policies and update them where needed to add this new leave. Obviously, it's an unpaid right is the basic minimum. If you choose to pay it, obviously you are entitled to, but obviously it's set out as an unpaid right. Next slide, please. So paternity leave, again, this is a new change. At the moment, fathers and partners are entitled to 2 weeks 2 weeks paternity leave, and obviously they can take that at the moment within the first 8 weeks of birth or adoption. Now, the other issue is if they take 1 week and don't have their second, they have lost their second week. So the changes coming in really are, it can now be taken as 2 separate blocks of 1 week, or still 2 weeks if they wish. And it can be taken at any point in the 52 weeks after birth or placement for adoption. So you can choose to have it on the first week of birth, and then 6 months later have your second week, for example. The only difference really on notification has been 15 weeks before the due date or date for placement. You just have to give your intention to the employer that I at some point will want to take my paternity leave, and then provide 4 weeks notice for the actual dates that you want to take the leave. So that is quite helpful to allow families to plan a little bit more in regards to partners taking this additional leave. Next slide, please. Concurrently with this, redundancy protections are expanding. So currently, people who are on maternity or adoption leave or shared parental leave should be offered first refusal for any suitable alternative role if there is a chance that they might be made redundant or in scope for redundancy. But obviously this changes or this stops the moment they return to work. So this is kind of expanding quite a lot really for these sorts of people. So the protected period is now covering pregnancy. So that is the date you notify someone that they are pregnant, or you notify your employer that you are pregnant, I should say. And will last to 18 months post the date of birth or placement for adoption. As it says there for maternity, it's estimated week of childbirth, but obviously if you inform your employer of the actual date, then these timeframes shift. And for shared parental leave, again, they will be covered, but the only difference really here is they must take 6 consecutive weeks of shared parental leave, otherwise they won't really benefit from this protection. So it's just something, again, for employers to be aware of, that if you are looking at redundancies in the future, you're going to have to keep track of people who are on maternity or shared parental leave or adoption leave, that this protection will last longer than has previously lasted for. So obviously just being careful to make sure you don't fall into the trap of selecting someone for redundancy or putting them through a redundancy process and they have this additional longer running protection. Obviously, you may end up in a situation where you have more than one employee benefiting from this protection and you have a redundancy situation. And obviously, that is something you need to quickly address because they are both entitled to first refusal for suitable alternative roles. So that will need to be dealt with before you move on to every other set of employee who's within that global pool. Next slide, please. So just on the redundancy protections, I think the next one is, yes, it's just the extension will apply for leave that has already been taken, but it will end on or after the 6th of April, and shared parental leave that is starting on or after the 6th of April. So next slide, please. A little bit in the sense of this then on Horizon Scanning with family-friendly rights, neonatal care has it is on its way and it is going to start in 2025. It will be for employees and there will be minimum service and earning requirements to come in. But effectively, this is if your baby is, once they are born and within the first week to 28 days of life, they are required to have some form of care. They're staying in hospital. There's basically anything, these sorts of issues that require them to have some form of care that isn't basically at home. You can have additional 12 weeks extra leave and pay. Now, at the moment, with the way maternity leave and maternity pay schemes work, this will all be tacked on to the end of someone's maternity leave, because obviously if they switch to neonatal care leave and they've given up their rights to maternity leave and pay. So obviously the government at the moment doesn't want that to happen. You shouldn't lose your entitlement because you're taking a different entitlement, so it will be tacked on at the end. Now obviously between now and sometime 2025, when these come in, they might change the rules on maternity leave and pay. If you are taking neonatal care, it's at the beginning and you are still entitled to your maternity leave and pay, or it still might be tacked on at the end. So it's just something to be aware of if you need that it's a right you have at the beginning. You just see the benefit of that right at the end, so you don't lose your entitlements in the way. Next slide, please. So protection against sexual harassment. This is a new enhanced positive duty that's coming in September this year. So currently the defence for harassment, and this is of any kind on any protected characteristics, is that the employer will have to show that they took all reasonable steps to prevent that harassment. It is still a very high bar of defence, but however, now for sexual harassment and sexual harassment alone, they'll have to show that they have taken proactive steps in the workplace to prevent discriminate or this harassment from taking place at all. So things like they'll have to show targeted measures, additional training, anything where they can show we have done all that we can and did it before this happened to try and stop this from happening. It is the defence. So again, I think it's making that high bar slightly higher. Now, if a claim for sexual harassment is successful in the ET, obviously they will now look if you have breached this enhanced duty, and if you have, then obviously they can award a 25% uplift on compensation. Also, the Equality and Human Rights Commission will be gaining a power to enforce this duty against employers as well. So it's really something to be looking at what your training is. Is your training up to date? Is it mandatory? If it's not mandatory, it really needs to be made that. And if things aren't, if people haven't attended their mandatory training, that they are made sure that they do so, because obviously this is landing on the employer's doorstep. And if you haven't really able to demonstrate that you have taken these proactive steps, you are looking at a 25% uplift if someone unfortunately suffers sexual harassment in the workplace. And next slide, please. So just some key takeaways, really. Update your policies. We already started seeing people proactively looking at what they want to do in regards to some of these policies. So obviously, if you want assistance on that, please do contact us. Make sure your processes are up to date and your managers are trained on them. So certainly around flexible working, are your managers aware that they're going to have to now deal with all of this within 2 months rather than 3? If they're not able to deal with these because of time pressures, make sure you've got some form of pool of people who can deal with these. Because if you don't, you're obviously going to run the risk of statutory breach of claims of statutory procedures. Consult with your unions on holiday pay if you are going to change how you're doing it. And if you've got redundancies coming after the 6th of April, obviously you may not know that yet, but making sure that you know who is on what form of leave, so you don't end up with accidental discrimination because someone has returned from the workplace, still has enhanced protections, and you are accidentally putting them towards, or you're not accidentally, you're putting them through a redundancy process and they should have had automatic slot into suitable roles. And audit your policies and look at actions to prevent sexual harassment, get programs in place to show that you've taken positive steps and that you've done all that you can really to prevent harassment in the workplace. So that is me on things that are coming in the next couple of months and year, and I will pass over to Medina, who is also looking at some horizon scanning.
Good morning, everyone. Thank you, David. I'm going to cover horizon scanning. So following the leading decision in the Supreme Court case of R on the application of Unison and Lord Chancellor in July 2017, the application of fees on claims were quashed. The Supreme Court in this case held that the fees were unaffordable practice, that the charging of fees meant that it was worthless to pursue low-value claims or claims seeking non-monetary judgments, and fee structure was indirectly discriminatory towards those with protected characteristics, including race, sex, and disabilities. This month, the government launched a consultation on a new proposed fee regime for claims in the Employment Tribunal for appellants to pursue appeals in the EAT. The purpose of introducing fees for legal cases has always been to reduce the burden on the taxpayer and to maintain open justice. Presently, it costs approximately 80 million per year to run the ET and the EAT, and 58 million to fund ACAS. Moreover, they also aim to reduce ET claims. The consultation announcement highlights that case numbers has increased around 18,000 in the year 2016 to 17 to 33,000 in the year 22 to 23. The aim of the proposal is for parties to settle claims early in the ACAS early conciliation so as to avoid to going to court. The current proposal is for the ET and EAT cases to be around £55. There are also some cases that will not be charged based on specific reasons, and the government has proposed for fee remission on for individuals who are from low-income families. The government has said that it believes this will result in a reduction of cases by about 20% and will generate an income of 1.3 to 1.7 million per annum for the year 25 to 26 onwards. We do not expect that with this proposal, which is a flat, small fee. Can I have the next slide, Sean, please? Thank you. With the prospect of a general election this year, the Labour Party has released their employment rights green paper outlining their plans for significant changes to employment law if they win. The Labour Party plans to prioritise pay, security and equality in the workplace. They also suggested that they will introduce a new deal for working people within the first 100 days of government, which includes raising wages, enhancing job security and expanding worker rights. One of the most significant proposals is to create a single worker status and extend unfair dismissal protection to cover all workers. In the UK, unlike many other countries, such as the US, France, and Australia, who operate on a two-tier employment status category, the UK recognises three types of employment status. This includes employees, the self-employed contractors, and workers. This would effectively mean that all workers would be eligible for the same benefits, such as sick pay. Additionally, the Labour Party intends to eliminate the 0 hours contracts. These proposals would grant immediate rights and protection to workers without any qualifying periods, but would impose significant costs on businesses. The proposed changes to unfair dismissal outlined in Labour's Green Paper would significantly affect employers in the UK, prompting them to assess their approaches to dismissals and recruitment processes. The proposal reforms currently include the following changes: ending the 2-year qualifying periods for employees to bring an unfair dismissal claim and making it rather a day one right, removing statutory caps on compensation a worker can receive if they are successful in bringing a claim for unfair dismissal, and extending the limitation period for claims in the employment tribunal from 3 months to 6 months. The proposal changes will prompt employers to adopt more rigorous recruitment practices to ensure the right fit for their organizations. This means that employers would need to use their probationary periods effectively and to implement robust performance management systems to monitor and document employee capabilities, as poor performance is often a valid reason for dismissal. And HR representatives and managers would need to provide training and support, such as performance improvement plans, as an alternative to immediate dismissal for underperformance. These changes may result in larger termination payments to settle potential dismissal claims, reflecting the increased bargaining power that could arise from uncapped compensation for unfair dismissal. In relation to equality and diversity, the Labour Party has announced proposals to honour the UN Convention for the Rights of Disabled People and to introduce mandatory disability pay gap reporting for larger businesses and facilitate workers securing reasonable adjustments from their employers. They have proposed to introduce a new race equality to tackle structural racial inequality, which was first announced in 2020 and included tackling the issue of low pay for ethnic minorities, with fines for organizations not taking appropriate action on their pay data. Lastly, to implement the Equality Act socio-economic duty on certain public bodies, which will require these bodies to adopt measures to address inequalities resulting from occupation, place of residence, education, and social classes. And finally, in relation to other proposals, whilst the extension of employment rights to workers and to workers and extended unfair dismissal rights are most eye-catching of Labour's proposed reforms. There are others, all of which will create a significant additional protection for all workers and corresponding compliance for employers. These include to ending fire and rehire, updating trade union laws, including granting trade unions a legal right to access workplaces, and increase national living wage to a rate that working people can actually live on, and to expand the low pay commissions remit so that national living wage for the first time could take account of the cost of living. And finally, to repeal the Minimum Service Levels Act. This is the stamping out blacklisting and simplifying the statutory recognition process to ensure gig economy and remote workers can organise through trade unions. Thank you for listening. That concludes our slides.
Thank you very much, Kit, David and Medina for finishing off there. That's really useful.